All right, I'm recording. So, let's get started. All right, well, welcome everybody, and we will be joined shortly by others, I'm assuming, but I want to take you back to the Blackboard shell. We always start at the Blackboard shell to talk about where we're going, and as I mentioned, as we first got started, tonight truly is the last time we as a group will get together to have a Zoom session. Now, we have one scheduled for the week after next, but we'll talk about that in a minute about what I want that one to look like. So technically, this will be really, for most of us, our last night of Zooming as a class. Of course, we've got 2 more weekends to go, so we'll have plenty of opportunities to see each other. But let me call a couple of things to your attention. The course calendar, of course, we're following that. We've got one more Zoom session planned, and that one is for November the 7th, but I will talk about that. We have 2 more weekends coming up. We have that August the 26th and October 26th and 27th. We'll start at 6 o'clock on the Friday. We'll be at the Stone Center in the Wilkesboro, and Saturday we'll do the 9 to 3. What we're going to concentrate on the next weekend basically is going to be the laws and court cases. We've kind of spent the first part of this semester, or most of the semester, talking about board policy, and that's kind of the horse, the wagon. And now we're going to talk about the horse that's dragging the wagon, which is, of course, laws and court cases and decisions. So we'll talk about that. Then our last session will be on the 16th and 17th. All right, a couple of things I want to call your attention to in Blackboard. I have a new feature on mine, which I'm not sure that you do, but it's called Quickly, or whatever this is, Quickly. It does give me the opportunity and the ability to send you all announcements. So you would have noticed that here on your my shell for 708, there is an announcement about the Chairman Jones video. That was a video that Dr. Bull, our dean, was a part of, and he had a part of being on the panel. It's about Chairman Jones, who was the first African-American board chairman in Halifax County, North Carolina, up in the northeast North Carolina. And it talks about, he had a 7th grade education, and talks about the challenges that he had to overcome in order to be an elected official on the school board for Halifax County. So exceptional video, great. And so he sent a link to it. So if you want to watch that, it's about 60 minutes. But it's a great opportunity to hear about a forerunner in North Carolina, and that's Chairman Jones. So you can see I sent that video to you. I also have sent you somewhere, you should have gotten an invitation to have a meet and greet with the dean. I think it's called some kind of session with the dean. If you're interested in that, I think it's the 24th, I believe. I'll have to go back and find out where that is, but that's available too. The neat little thing is I also have this needs grading. You all don't have this, but it brings up the 2 courses that I have that I currently teach, and it brings me right up to, I can click on 708, and it tells me that I have nothing to grade. You guys have already turned in everything, or everything you've got, so I'm waiting for you to fill this page up for me, because there's a lot that we need to do. So that's one of the other things. Let me go down to our week 6. And Pam, just so you'll know, I still cannot get 3 and 4 to get together right. You should be doing the ethics scenarios 6 and 7. You guys are doing really great with those, and I'll talk a little bit later on at the end of the session about some of the commonalities I see on some of your ethics replies. I also put an article in here about the North Carolina voting numbers, since we're starting in today was early voting. Some registration, some information about your county. Let's pop on down to Wilkes. And you can see that in Wilkes County, it's kind of hard to read, but, well, let's don't do Wilkes, because you can't read the top. Well, if you had it, you could. But this basically gives you a breakdown of the people in your county who are registered. You see in Alamance County, which is Burlington, there are 38,000 Democrats, 33,000 Republicans. Actually, a few other parties are listed as well. But if you will look at this chart, and the reason why this chart is here, other than it's just great information, you can also break down by the number who are unaffiliated. And unaffiliateds are they're the fastest growing population of voters in the state of North Carolina, And in our last session, our last face-to-face, we're going to talk about advocacy and how you can plug into that. But you can see they almost number, and in many places, they do outnumber either the Democrats or the Republicans. And an unaffiliated is someone who goes to the polls and can vote in either one of the primaries, either the Republican primary or the Democratic primary. They can't run a candidate because they are not a party unless they do, they have to have a petition to get 5%, I believe, of the candidates. But it breaks it down so you can see how many of the registered voters in Alamance County are white, how many are black, American Indian, Hispanic, how many males, and if I were to move it, if I could, it would be females. But it's a really interesting little statistic that you might want to go and look up. Here's Burke. You can see in Burke, the Republicans outnumber the Democrats, but it's not, the unaffiliated outnumber the Democrats. So the unaffiliated are really the ones who decide a lot of elections in North Carolina. So interesting statistic. Anyway, I want you to see that. Going back now to Blackboard. Tonight we're going to have a couple of presentations. Pam's not going to do hers tonight since she doesn't feel well. Frida's going to do hers on Brown versus the Board of Education on the first Friday for our work session. So we will take care of those. Let me, our next face-to-face session, which is the next class after tonight, will be in Wilkesboro. You do not need to do anything, and if I would erase it, but I didn't want to because I may need it later. Do not do anything but maybe go up and look at these two articles here. The News and Observer article about the GOP and the school district breakup. Do not, you can watch Rock, but do not do anything else with this particular Blackboard page. So really all you need to do is look at these two articles and maybe watch the video. He does a great job there. We're going to do something different, but it'll be when you get there on Friday, we'll talk about what we're going to do on Friday and Saturday. I do want to call your attention to our next class, Zoom class, which is the 7th, week 7, which is November the 7th, the day after the election. There is nothing in it because I have added a new category called EDLS 708 personal conferences. So I want to spend a minute to talk about how this is going to be managed and how we're going to do this. This is a Google document. When you click here on your page, you'll see something that I've added. It's the EDS 708 Zoom session personal conferences, November 7th. When you go in and you click on it, it is a Google Doc. You should not have any problems filling it out, but basically, here's what we're going to do. It should be November 7th. Let me fix that. All right, here's what I want to do on November 7th, which is our next Zoom session. I realize that we've covered a lot, and you all had to do a lot by reading the chapters and reporting out on them. So really what I'm proposing is that we do not have an official Zoom session on November the 7th. I would, if you would like to, I'm going to be available from at least 6 until 7:30. And if you would like to sign up for about a 10-minute session to talk with me about anything, or to talk with me about where you are with your grades so I can bring you up to speed. Here's what I'm missing. Here's what you need to bring in. Because by the time we finish on November the 17th, we will be done. And I would like very much for you to be done by November 17th so I can go ahead and turn in everything. I have until December, the 1st of December, to turn in all my grades. But technically, I'm hoping that all of us will have everything ready by November 17th so you can concentrate on the holidays and the last month of school. So here's what I need you to do. I want to remind you that if this is only if you want to, you will all get a Zoom invitation at 5:55 on November 7th, and you can Zoom in or not. If you want to Zoom in, though, I ask that you go ahead and sign up for one of these times. And basically, really, the only thing I want to talk about are two things. One, what is it you need to get? If you're unsure about how many more things do I need to get before I have all my work done, it really is to kind of give you a personal conference where we can talk about where you are. It is also, because it's not a lot of time, to talk about any other things you want to talk about. Career advice, not that I would come to me for career advice, but anything else that you want to talk about that would be beneficial to you. I want to give you an opportunity. And if 10 minutes is not enough, shoot me an email, and I'm around until 8:30, 9 o'clock that night, so I can actually have some more time. But so all of you at 5:55 will get a Zoom invitation. And if you, and here's the other thing about this too, please, someone, if you come in at 6 o'clock, next person, please don't wait until 6:50. I would like for you to fill it up as we go, okay? Because this is a required, you would normally have had to be here anyway, because it's one of those classes that you have to be here. So please, if you see someone's taking 6 o'clock, do not come in at 7:20. Come on, give me a little break here. Try to back them up. So if you see someone, just fill in right after them. And it's not that I don't want to wait around. It's just I don't want 30 minutes of Zoom time in which I'm not, and I'm not sure I know how to redo Zoom and all that. So if you want to, totally up to you. If you want to just watch, come in, I would prefer that you not watch the sessions that I have with everyone. So if you're the 6 o'clock and you Zoom in at 6 and we're done at 10, you check out. So the next person can come in at 6:10. I can have a private conversation with them. They check out at 6:20. 6:30 comes on board. So if you want the 10 minutes, sign up for it so I'll know who I'm going to be talking to so I can begin to pull together my records for grace. Now, this is 2 weeks from now. Again, you're not required to attend, but do try to, if you need to. I really want to go over what's missing, what you need, how far you are along the way, and any other thing you really want to do. If you want more than 10 minutes, talk to me about it. We can do something after the 7:20. If you're having trouble, this is a Google document, so I've been told that you can fill it in. Can someone try to put something in at 6 o'clock so I can make sure you can do it? I mean, you don't have to keep it, but if someone could, or sometime.
How do we get to it? I didn't hear where you said it was located.
It's a link under here. It's EDS 708 Zoom session 7. Do you have it?
No, I do not see it on my dashboard as an option.
Really?
But let me refresh.
Does anybody else not see it? It's over here on the shell. And it's after the face-to-face October 2nd. October.
Dr. Stone?
Yeah.
How are you? Good evening. If you share it with each one of us, then we'll get it in our Google Drive.
See, and I was told that you already had it. So
we have it, and then we can just go to that. Whatever.
I just don't see it. It may be that I'm doing something incorrect. Kristen, do you see it?
Okay. What I will do is tomorrow.
For some reason, it's not showing up in the.
Okay. So what I'll do tomorrow is I'll go in. Thank you, Lakeisha. I'll go in tomorrow to Google Drive and share it. I did not know that I had to do that. I will learn something new tomorrow. Anyway, when you get it, just realize that it's an opportunity to sign in. You don't have to. Any questions about it, just let me know. Look at that. It didn't even save it. So I've got to go into my. Well, maybe I can do it right here if somebody shows me how.
If you can figure out how to have it listed under the weekly content, we should be able to select it.
Yeah, that's what I thought too.
It's just not listed under the weekly content.
We could select it, but if you hadn't given us access, then it's still gonna say we need access.
Okay, I'll do that.
Let you put anything in it.
I will do that tomorrow. So you can, but you all have an idea of what I'm looking for. If you want to, I'll share it tomorrow with you. All right. Okay. Any questions? Oh, and by the way, then the last week, of course, the last is the face-to-face session, which we will populate. Again, I've got what's due checklist of the things that should be checked in. So you may want to reference this. This is, of course, in the last week in the face-to-face session. All right.
Dr. Stone?
Yes.
Also, we do not see face-to-face 3 as an option on what you're pointing to right there.
Ah, you know why? These little boxes are checked. That's why. Hang on.
Yeah. I think you just need to make it available to us.
Yeah, that's exactly why, because those little boxes are checked. Okay, I'll have to figure it out. Sorry. Let me make a note.
Okay, I see the Zoom session now.
I can see it.
So whatever
Yeah, I can see it now.
to make Zoom session available. Oh, now you're going to have to change your settings in the Google Doc to give us access.
Now do you see face-to-face 3?
Let me refresh.
Yeah, because the box is gone.
I do. So the only thing you have left to do is go to your Google Doc.
Yeah.
And you just need to change the settings, which maybe during the break, one of us can walk you through that.
That might be a good idea.
It looks like you have it in view only.
Okay.
Yeah, this what we're working on is for next class, right?
Yes.
Oh, okay.
I will have it ready for you. I'll figure it out tomorrow. Someone maybe can help me. All right, moving forward. Are we ready? So everybody understands about November 7th. I'll fix the Google Doc. All right. Who is first? Cynthia, you're first.
Yes, sir.
Hang on, let me. I've been practicing this week about how to turn over the host thing, so it is yours, Cynthia.
It says that you're still sharing.
You would think. Let's see. There it is. All right, now it's yours.
Okay.
Oh, by the way, when y'all evaluate me, don't mention my deficiencies in technology.
Okay, can you guys hear me?
Yes.
Okay. So my chapter is about recruitment, tenure, dismissal, and due process, chapter 10. When you are recruiting and interviewing, it is important that you create a positive impression on the candidate, almost as if give them the opportunity to interview you, so to speak, so that you leave a good impression if that's the candidate that you want. You would want to be well organized, and you would want to follow the same process for every interviewee so that everything is legal and consistent, and that includes even your scoring system, and the questions that you ask should be purposeful, direct, and to the point. It is also recommended to keep good records of what you're doing, of what the candidate says, and document that so that at the end you would have the opportunity to reflect back on your notes. And then, of course, references are very, very important. Sometimes not recently, it doesn't seem like, but there are times when incentives are offered to attract some of your best personnel. How many of you currently have an incentive program in your district to attract a certain type of teacher with a certain certification? Is there anyone who has that?
I bet Winston-Salem does, don't they? They do not?
Okay.
Not that I know of. No.
Sometimes you could check to see if there's an incentive for EC teachers. There was a time there when exceptional children's teachers were being focused upon. Some of your harder to reach areas like maybe your sciences, specifically biology in high school, sometimes are hard to get. So, take a look at your policy and see if you have an incentive for like maybe a signing bonus. Also, you would want to avoid any type of discriminatory questions, questions about religious beliefs, age, things of that area, that type of thing. And then be sure that you do a thorough reference check. And one would assume, this was not in the book, but that the most recent place that the candidate worked would be listed as an opportunity for you to check references. If not, it is a good practice to call and check into their most recent employment.
Cynthia, why would you not ask for a picture? What do you think?
Well, there again,
you cannot ask for
race and looks and size, and it's really not about that. It's about the qualifications the candidate carries.
That's right.
Is that correct?
Yes, it is.
Okay.
A picture will tell you, it may tell you their religion. It will certainly tell you their race. It'll tell you their age. It may tell you their disability.
Absolutely.
Maybe. And those are all prohibited employment practices.
All right, discrimination. Districts with a well-defined and focused process that is legally defensible tend to have a greater recruiting and minimize legal challenges. In this chapter, there was a situation where there was a case in California, and I want to look at my notes here, where 2 Jehovah's Witnesses applied for a position in California. It was actually at a community college district, and in accordance with the state mandated pre-employment procedures, the district required the applicants to sign an oath swearing allegiance to the U.S. and California constitutions. Why might there be a problem with that? Why would someone have a problem signing an oath swearing their allegiance to the Constitution? Anybody want to take a guess? I gave you a big hint on the screen. They were Jehovah's Witnesses, and that violated their religious beliefs. So obviously they refused to take the oath. The district rejected their application. They filed suit against the district under the RFRA, which is the Religious Freedom Restoration Act, challenging the validity of the loyalty oath. The court held that requiring them to take that oath placed undue burden of their right to free exercise of religion. Although the employee loyalty was a compelling state interest, there was evidence failed to establish that a loyalty oath was an effective way to achieve this goal. So basically, the court's saying there are other ways to achieve the same goal without requiring someone to sign that loyalty oath. Tenure, non-tenure. Does anybody want to take a guess where our state currently stands on tenure and non-tenure? Anybody know? Does the state of North Carolina have a tenure law? Anyone know?
I do.
I mean, don't we? I mean, we used to. I mean, people are grandfathered in, but now the new teachers, they don't have, they cannot earn tenure, correct?
That is correct.
Yeah.
Was someone else going to add something? Okay, so tenure is defined by state statute. Tenure is designed, let me pull all these up so I don't distract you. Tenure is designed to protect the teacher. It provides a measure of security for teachers. It ensures they are protected from arbitrary and capricious treatment. And when there was a day when there was a probationary period, or when you talk about a probationary period, that's the time before a teacher reaches tenure. So what do you think about the statement, tenure is designed to protect the teacher? All teachers? What are your thoughts on that? Is tenure designed to protect all teachers? Some teachers? Teachers that follow policy, teachers that don't follow policy. Okay, y'all are a quiet group tonight, so I'm just.
That was the intent behind tenure,
It
but I
was.
don't think that was actually how it played out necessarily.
I would agree. I think you have to be very cautious about how you look at tenure and what it's designed to do. And a teacher, we all have observed, whether it was formally or informally, the teacher who did just enough to get by, so to speak, who followed rules and procedures at the basic minimum, who did what they just had to do in the classroom and they were not effective. And then there was that big discussion of, well, how do you get rid of, which that's a statement I don't particularly care for. How do you get rid of a teacher? Well, I would choose to look at it. What are you doing? What is administration doing to address those needs, those concerns? If there are concerns in the classroom and a teacher had tenure, what did you need to do as an administrator? And sometimes we found that administrators were not willing to do what it takes, which is to truly address the needs of that teacher. Just because there's needs sometimes does not necessarily mean that they are bad. It may be you have a young teacher who doesn't know how to offer a rigorous 90-minute block of instruction. So sometimes I think the fault lies just as equally on the school system, who doesn't address the needs as it does with the teacher who may not be doing what they're supposed to do in the eye of the beholder. And that was actually my opinion, not in the book. So non-tenure. There is no expectation for employment beyond that contract year. I apologize for that mistake there. I will correct that before I turn that in. There's no right to be provided reasons for non-renewal. In other words, you don't have to give a reason if there's non-renewal.
Yep. No I can do better.
I'm sorry?
You can say I can get better. I can get somebody better.
No rights to due process and no hearing. Now, yes, you can say I can get someone better. But I think, Dr. Stone, I think you would agree with me that if you are going to release a teacher that does not have tenure, it is highly recommended to have documentation of why.
Oh my gosh, yes. Oh yes.
And
that may be your real reason that you could do. That may be your real reason that you could do better, but you better have some paperwork to go along with it.
Absolutely, and you better have more than just one try of trying to help the situation, help the teacher. You know, one of the practices that I have is anytime I'm in any type of, I'm going to use the word situation loosely here, with a teacher, with a parent, whether it be a phone call, an email, a conversation, I always, in my mind, practice as if this particular situation is going to be taken to court. I don't say that to the other person, but in my practices and what I document, I try to be very thorough in what I document as my notes, even if it's just raw data. You know, you take a phone call, date, time. It doesn't have to be anything neatly typed out. Some of my best notes saved me one time in a situation where a parent was accusational, and I was interviewed by a lawyer and by the lawyers in DC, and it was my raw data that actually saved me. And it was every time I got a little note or I had a conversation in the front office with a parent, I just went back to my desk and I just wrote it down. I just documented it. It wasn't neat and it wasn't in a complete sentence, but it was thorough in what was being discussed. So you cannot document enough, no matter what the topic is.
Cynthia, could I add something to that?
Please do.
Actually, in Forsyth County, in addition to all that documentation, we actually have to meet with HR and also an instructional superintendent to review that documentation, to review observations, and a lot more information before we can move forward. So there's a process, if you will, a protocol that we have to adhere to, if you will, before we even move to the next step.
Right. And that's a good practice on the part of your school district.
Oh,
and
absolutely.
that is basically because if the situation were to be taken to court, they want to be able to say they have done A, B, and C, and they offered A, B, and C, and they tried to do D, E, and F.
Right. And sometimes even before that, the attorney joins the group as well to make sure that everything that we're saying that we have documented is actually we can defend if we need to.
And you guys are fortunate in Winston Forsyth to have an attorney on hand at all times. I do not have that luxury in Elkin City, and I did not in Wilkes County when I was assistant principal or principal. So don't take that for granted.
Absolutely
That is
not.
an awesome, awesome opportunity. You can learn so much from those discussions with the lawyer. So principal tenure. 13 states provide tenure for principals. Does North Carolina?
No.
No.
No, that is correct. North Carolina does not. This data that I have here is straight out of the textbook, and these numbers have changed, but I'm going to present to you what was in the textbook. At the time of the print of this textbook, there were 36 states that provided fixed-term contracts for principals. That is contracts for principals and assistant principals is one of the most common forms of employment for principals. Entitled to due process if the contract is canceled prior to the contract expiration date. So when you sign on in a contractual agreement, you are usually given 1, 2, 4. Those are some of the most common years in your contract. And if that contract is broken, you have the right to due process. And then there's a lot of discussions that occur with that. And a contract can be renewed based on the quality and effectiveness of your performance. And we all have been through, I would assume that we each have a contract and have been through the renewal process for a contract. Dismissal for cause. Tenure laws include grounds for dismissal in virtually every state. And these grounds normally include things such as incompetency, insubordination, neglect of duty, immorality, justifiable decrease in the number of teaching positions, and financial woes. It's a serious matter. The state prescribes permissible grounds on which a dismissal is based, and the burden of proof always resides on the Board of Education to show cause based on the preponderance of evidence. The dismissal cannot occur without a formal hearing and the presentation of sufficient evidence to meet the statutory requirement. So as stated earlier, documentation here is very, very important. And dismissal for cause assures the teacher that procedural and substantive due process requirements are met. So let's talk about incompetency. Very simple. This is a term we are all familiar with. It refers to the lack of skills, knowledge, intelligence, in some instances, professionalism. Insubordination. General Statute 115C, and that is a general statute we all have been familiar with, and unfortunately in my case I have been part of handing over the letter to a staff member who was insubordinate. I did not, as a principal, have the right to dismiss that person, who is the only person that has the authority to dismiss an employee, a teacher. Anybody know? It's the superintendent. Yes. So insubordination is that willful failure or inability to obey the reasonable and valid administrative directive. That does not mean, I'm going to add a little side note here, that two people cannot agree to disagree. It means that you are absolute insubordinate. You refused. You must have documented evidence of that misconduct in order for a directive to be followed through. You as an administrator or as a director in your school system should be knowledgeable, state statutory definition of insubordination. And again, it needs to be well documented. As I stated earlier, professional disagreements between superiors and subordinates do not constitute normally an insubordination. An insubordination is when it takes it to the next level, so to speak. Dr.
Yeah,
Stone?
I certainly wouldn't go in and tell the superintendent you're not going to do it because you don't like it or you disagree with him.
Correct. I was going to say, do you have anything to add to that? Because I felt like you probably did.
Yeah. Not a good professional move.
No. Neglect of duty, neglect. We know the definition of that. We know what the duties and responsibilities are. It's when the teacher fails to execute the assigned duties assigned. Sometimes that neglect may be due to unintentional knowledge of or acts, but then there are those cases where it is intentional, and that is when there is a right to investigate, document, and potentially could be a staff member can be released of their duties. Immorality. This is one that I have not personally had experience with at the administrative level, and quite honestly, I'm quite happy to say that I have not. But this section was quite, sorry about that. This section and the next next slide on homosexuality were pretty lengthy, and basically behavior that sets a poor example for students and violates their moral integrity is a definition there, which leads right into, in some opinions, not all, homosexuality, whether or not that is a violation of moral integrity. As I said, this section was quite lengthy in the chapter, and it was also pretty obvious in reading about some of these court cases how things have changed over the last several years with homosexuality and in our public, what is acceptable, what is not acceptable. But there are definitely some lines that are important to be aware of. If the act is private and does not involve students, there's a greater tendency to be supported by the courts. So private acts of homosexuality and adultery may not be grounds for dismissal unless you can prove that the teacher is being ineffective, unless this act affects their ability to perform their assigned duty. Another thing to keep in mind is if this act is how the community, I guess, embraces or the lack thereof of such acts. Let's be realistic. Elkin, North Carolina versus Las Vegas, Nevada. The community dynamics are very different, and the views of how homosexuality may be viewed are going to be different. I don't mean to be accusational toward Las Vegas, Nevada. I'm just saying that your community sometimes is more accepting or not. So lifestyle choices can be adversely affected by the teacher's ability to teach or his or her effectiveness to perform the assigned duties before disciplinary action can be taken by the school district. This text also referenced a case, I believe let me find my notes on this one, Brown versus Hardwick, was in 86, maybe? Yeah, that says that right there. I apologize for that. They needed, school officials. This is where a private sexual relations between consenting adults were now viewed as a liberty right that receives the 14th Amendment protection. If I remember correctly, this was in reference to two males who were in one of their private homes, and I'm thinking this might be the one where law enforcement entered the home for another cause, someone else reported there was an intruder, maybe, and law enforcement goes in and observes two males performing an act of homosexuality in the privacy of their own home. And so, of course, this was challenged in the court system. And I believe it does go back to how did it affect their performance in the classroom. There were several examples in this section about such situations.
My advice on that one, if I may, Cynthia, is as you all get into this, you are going to find this will come up occasionally. As the court ruled in June 2015, gay marriage. I mean, this is an issue that's front and center. So you are going to have more and more teachers who are coming out of the closet, who are going to self-identify. So I would tread lightly. And certainly if you ever have a case where you're even discussing dismissal, you better have that lawyer on board, because this is untested court cases. And you do not want Elkin City to be the test case with the U.S. Supreme Court or Wilkes County or Winston-Salem Forsyth. So tread lightly on this one, as well as any issues related to
transgender
or sex. I mean, if you've got a female teacher that's just putting out on Facebook and all sorts of stuff like that, tread lightly, because there's a huge undecided issue of private versus public, what First Amendment rights you're losing, what due process or 14th Amendment rights you're losing. So just tread very lightly on this. Even if you just have a conversation with the teacher, I would be very cautious. Even if you just want to pass them in the hall and you may want to say, hey, Ms. Smith, call me, we're concerned about this, I would tread very lightly, have a lawyer involved.
I have a question.
Yeah.
Remember there on the news, there was a teacher, I think she was dismissed. Her recreational activity was pole dancing.
Yeah.
And she didn't share it, but somebody else did.
Yeah.
I mean, how could she be dismissed for, you know what I'm saying?
Yeah. I would imagine I don't know if the court case has ever been decided or if she just decided to drop it out of embarrassment, but I would dare say that if that was, I dare say she'd have a court case. Okay. If they have violated her rights. But I don't know what happened to the case. I don't know the name of the case or anything, but I would think that I would say she's got a case.
Okay.
I mean, she's not pole dancing in class, is she?
No.
All
And
right.
she didn't even share it on Facebook. I mean, she didn't share it with everyone on Facebook. Someone, I guess, shared her information with others.
Yeah, that's all that. That's why you need to tread lightly, because that would have been one that the lawyer would have made a call on instead of me.
Okay.
All right. Financial exigency. I can't say that word very well, but I did the best I could on that one.
Looks good to me.
Okay. So basically with this, you're dealing with positions that may be terminated due to the reduction in student enrollment, which I will tell you in Elkin City, that is a topic that we discuss yearly. We are a city school system. We are one of 3 in the same county. So we are always looking at enrollment numbers and how those numbers will affect our number of positions. And I will tell you that one hit way too close to home for us. Is something, we want to protect every teacher that we have because we think we have quality educators. And I dread the day when, we have to do more than that. And Pam Colbert can speak to that. She too fights that internal competition of, will we have the numbers that we need to keep going, so to speak. Also, reduction in force, RIF policies, as you've heard them called, are procedures that you have in place in your school district. Those are in your board policy. If you've not ever looked at those, it is a policy that I would recommend that you look over sometime and be aware of. School districts develop and they follow objective criteria in making those RIF decisions. And when you're looking at a RIF position, and I'm going on memory here, you're looking at, if you RIF a person, Dr. Stone, help me out with this. If you RIF a teacher, then they should be next in line for reemployment of the same certification, grade taught, content taught, etc. You can't put someone else in that position. Is that correct?
That's best practice.
Okay, is that practice?
That's best practice, but I don't think, unless your board policy addresses it, I don't think it's certainly not the law.
Okay,
Cynthia.
I think it does in our policy, but I'm going to look that up to be sure. I'm not sure. I know for sure. Go ahead. Yes, Pam.
Cynthia. A couple years ago, that's the first time I'd ever had to work with that. And one thing that I learned about it was that we did have to offer that person they got, we had a position that became available later. That person was not certified in that content area, but we also offered it to them if they were willing to go get the certification. And the other thing that I didn't realize was because that person was rifted, then we had to provide them insurance
Yes.
for a year.
I was getting ready to say that.
I didn't know that. So,
Also, can I ask a question, Pam? Was this person tenured?
no, this was a BT teacher because we took the last one who was hired, and that's how we worked with it.
Okay. So that's your policy.
I think it is our policy as well, Dr. Stone.
Okay.
Which might be why I thought it was like, I don't know, the law.
No, because remember, if they are now teachers, except for the ones with tenure, the ones who are now contracted, at the end of the year, you don't owe them anything.
That is correct, which changes the dynamics of your RIF policy or of RIF procedures. All right, good or just cause. Guys, I apologize I'm taking so long on this. Causes not specifically identified in state statutes, hence just is a broad term. So of all of the reasons that I've identified earlier, from insubordination to immorality, homosexuality, etc., good and just cause kind of is a catch-all. But it does not mean you can arbitrarily dismiss the teacher, and burden of proof always or should reside with the school officials. Fair Labor Standards Act. The intent of the law is to ensure that non-exempt employees receive fair treatment and appropriate compensation for performing their assigned duties. This was enacted in 1928 and has been amended multiple times since then. This refers to your clerical staff, your food service personnel, your custodians, maybe security, teacher assistants. Who else? I'm trying to think. There'd be somebody else that might involve.
Anybody that punches the clock.
Anybody that punches the clock, basically. Anybody that doesn't have a contract.
Yep.
Collective bargaining.
Back to this. I'm sorry, I'm slowing you down too.
No, sorry.
Those of you who've been in administration for at least 10 years, you know that probably about 10 years ago, we had to start using punch clocks.
Yes.
It used to be, we had a real simple system that if you were a 40-hour employee, you didn't have to punch in anything. You worked overtime, kind of agreements. If you worked 42 this week and 30. But when we had a whole bunch of lawyers come through who used the FLSA. And that's why we really had to get to that point where we started using, what did we use? Power School? No, what is it?
Timekeeper is what we use.
What?
Timekeeper?
Timekeeper, that's what we used. That's why you started using that stuff, so you could beat the lawyers at it. Go ahead.
Okay. Collective bargaining. This is a topic that many of you may not know a lot about. I certainly don't know a tremendous amount, but the intent is to create teacher empowerment and shared power between teachers and school boards. You got your private sector versus your public sector. Private, you don't have the constitutional protections. Bargaining rights are restricted to the National Labor Relations Act, and basically means you're allowed to strike.
Yeah, and the reason why we don't know much about it in North Carolina is because it's illegal.
Exactly. Good. You just made that slide a lot easier.
That was a lot easier one.
It was. I'll skip all that hoopla.
You can skip this one because it's illegal.
That's prohibited. And
I'm not rushing you.
I'll just move on.
No, I'm not rushing you. I was just.
No, seriously. I was going to say the same thing, and why I repeat when you are with me. Now I got to turn my page. Hold on. My dog's trying to eat my popcorn. Okay. Impasse and bargaining. When parties involved fail to reach an agreement and no further progress toward a resolution. So you have mediation, you got fact finder, and you have arbitration. Mediation is pretty, that's pretty cut and dry. Neutral parties engaged, and both parties are allowed to dispute their side. Fact finders, when you got that third party who attempts to find the facts and determine what the compromise should be. And arbitrations, when your third party performs similar functions to those performed by the fact finder, but arbitration is binding, and what is recommended must be done by both parties involved. Have any of you been through mediation with an exceptional child's services? Anyone been through mediation? And that says meditation. That is not what that's supposed to say. I apologize. See,
I have a question.
Yes.
Going back to your collective bargaining, I know that we're not a collective bargaining state, but many teachers feel like NCAE is their I guess bargaining power. So where does really NCAE stand? Really, they have no. I mean, they can share suggestions. They can, stand on the rights of teachers, but there really is no.
They can lobby,
right,
for teacher.
The NCAE is not a union, and unions are the ones who do the collective bargaining. The NCAE, if you belong to NCAE, it used to be you got insurance, liability insurance, and if you ever got into trouble, they would come and sit with you and talk with you while you're talking to your superior, and then they would represent you in court. But they are not a union, and they cannot offer any collective bargaining rights or anything like that. So the benefit of belonging to the NCAE basically now boils down to you've got a lawyer and an advocate in case you find yourself on the other side of the table with the superintendent.
Thank you.
You're welcome.
Good job, Dr. Stone.
You're welcome. I've lived this stuff for 20 years. I've met many NCAE advocates.
Yes, sir. I'm going to leave it at that. I'm not even going to go there. Okay, so legal issues and workers' compensation. So occasionally courts have found it necessary to intervene in attempts to settle a dispute involving teachers, school board, or union officials. The employing agency should assume the responsibility for the injury suffered by employees during the conduct of the agency's business. To me, those are common sense. Maybe I shouldn't say common sense, but I feel like we've all learned probably a little bit about those in some of our experiences or coursework earlier on. Do you have any questions about workman's compensation or other legal issues that I have talked about? And for some reason, Dr. Stone, this was a much harder chapter for me to articulate than the one on religion.
It's interesting. Before you leave it, though, let me also say about those NCAE advocates. I have also been on many conferences where I'm sitting across the table with the teacher, and that NCAE advocate can very quickly tell that teacher, this is a lost cause. So probably on 75% of the cases where I've met with an advocate, an NCAE rep, and a teacher, that rep has done my job of talking to this teacher to resign. So actually, I count them as friends.
Yes, and you should. That's a good thing.
Yeah.
Okay, I'm going to try. That is the end of my PowerPoint, but I'm trying to get to my, hold on, I got to find the right tab to stop sharing. Oh, stop share, right there.
Okay. All right, Karen, you're up. Let me see if I can.
Thank you for your help, Dr. Stone. Seriously.
Oh, you're welcome. I enjoyed that.
I'm glad you did.
Okay, can you see my screen?
Yes.
Okay. And yes, I keep getting a message that says my my internet connection's unstable. So if I'm breaking up, I apologize. Just stop me if you can't hear me.
You really are kind of going
So chapter
in and out.
11 is the instructional program. Okay. Trying to think of what I can do to resolve the problem. Can you hear me okay now?
Now sounds good.
Okay, I'm going to keep going, but just stop me. So chapter 11, the instructional program and how that impacts school law and public schools. So first of all, education, the schools are a matter of state jurisdiction, state rights. It's not a fully regulated right, but it's left to the individual states, and that was outlined in the State versus Harworth case, where they said that it's not a matter of local jurisdiction either, that it's for the state lawmaking powers to determine whether the authority shall be exercised by the State Board of Education or if they wanted to counties, townships, etc. So the first topic in this chapter was compulsory attendance. The compulsory attendance law. What age in North Carolina do students by law are required to begin school? Anybody know? 7 years old. So at 7 years old, students are required to attend kindergarten. So compulsory attendance laws are based on the common law responsibility that parents do have an obligation to send their children to school, and the states have to ensure that students are provided an appropriate education. So that was in 1922, the U.S. Supreme Court ruled that states could require compulsory attendance, but also that attendance could be met through private schools and not just public schools. In another court case, Wisconsin versus Yoder, an Amish family challenged school laws. They didn't want to send their children to school after the 8th grade. And the U.S. Supreme Court ruled that the state's interest is not absolute and that parents do have some rights when it comes to religious reasons. So the courts are divided when it comes to compulsory attendance. Am I still good? Can you still hear me?
Yes, you're good, Karen.
Okay, thanks. Okay, homeschooling. Homeschooling has become more and more popular in the past 10 years or so, but the state does have the authority to define minimal standards for curriculum instruction, length of days, number of days for homeschooling. In a South Carolina case, there was a state that used a test to determine the ability for facilitating a homeschool, and that was ruled not reasonable. Some other court cases around homeschooling. Michigan, a law requires homeschools to comply with the teacher certification program. West Virginia, there was a case that a student would be ineligible for homeschooling if they didn't have a certain standardized test score. So if they reached the 40th percentile, then they were not eligible for homeschooling. And that was not upheld by the courts. Virginia, homeschoolers must be tutors or teach, but that didn't apply to private schools. So there was some dissension there among lawmakers. And in Maryland, the state monitored some home education programs, challenged curriculum standards that they argued that were atheists. So lots of different homeschooling case law out there. Charter schools have also become more popular. Charter schools are basically public schools that emerge from a contract with the state or a local board. Charter schools have yes.
Can I ask you a quick question before you move on? What about homeschooling in North Carolina? What do you know about it?
What I know about homeschooling in North Carolina is all they have to do is sign up for a homeschooling license and provide that paperwork to the school, and they can be considered homeschooled. There's really not a lot of regulations from what I understand.
Can a high school dropout?
For school students, because we typically get students.
Parent? Can a high school dropout parent have a homeschool?
Yes, in North Carolina they can. I don't think there's any regulations around who can be the homeschool provider.
No,
I think
none.
they have to get
I think they have to
don't
have a high school.
Am I correct?
they? Yeah.
Oh, they do?
I
I
thought
think
they have
so.
a degree.
What? I thought there was some religious exemptions and some things that would, because there's some, I don't know. I'll have to check on that, but I didn't think they did for some cases.
I thought they just had to have proof that they had a school, quote unquote.
Yeah, that's what I've always thought too, that they actually had an address for that school. But I will check on that because I have always,
Right.
but if I'll find out, because I've always thought that, you know, any Tom, Dick, and Harry can go down and get a homeschool address. And, you know, and that's, in my opinion of homeschools, and you didn't ask it, but my opinion of homeschools, you remember a couple of years ago, probably 10 in Caldwell County, Zara Baker? You all remember the case of Zara Baker?
Mhm.
Yeah.
Well, she
I do.
was schooled in 2 of our elementary schools, and then she moved to, it was either Burke or Catawba County, and Burke, and then they withdrew her from Burke and they homeschooled her. You know, my concern about homeschools is that they are so unregulated that the state makes no attempt to go out and check what they're doing. I think they're dangerous. My personal opinion of homeschools is not only are they dangerous physically sometimes, but if you've ever enrolled a homeschool child coming back into your school, my principals have always told me they can tell that this child is so far behind, and it is a horrible disservice to children. Now, I know some homeschool parents do a tremendous job. They really do. But I'm afraid that most of my experience with homeschool parents have been that they bring them back to us when they can't control them anymore, or it's way too late and that child is so far behind. But anyway, that's my take on homeschooling. I will find out if in North Carolina homeschools have to have
Yeah, I think I would agree with you.
I just looked it up, Dr. Stone, and it says that they have to have a high school, have to be a parent or guardian and have the equivalent or a high school diploma.
So they could have a GED.
I guess so, yeah.
Thank you very much. Answered question. That's good to know.
Good to know. And I would agree with you. I think there's a lack of accountability around homeschooling in North Carolina that we're going to have to work on. So back to charter schools. They do have more autonomy over the operations of their schools. They do have to abide by some accountability measures. The author of the book says, encourages innovation and creativity, but there are a lot of issues with charter schools that have come up, like auditing issues specific to financial concerns, poor record keeping, and student achievement generally has not been great, according to the author. But does Caldwell County or do you have charter schools? We have one in Burke County.
We do. We have one.
You do?
Mm-hmm.
Does it impact your enrollment a lot?
It does probably if you're on that end of the county, but it's actually close to Elkin.
Gotcha. So health requirements has also been in school law. It's always weighing parents' rights and state obligation to protect health and safety of individuals. So typically the courts are pretty consistent in that the state does have an interest to protect the health and safety of students. Most all states require specific immunizations. Some states provide certain exemptions. In Brown versus Stone, that an exemption based on religious grounds would discriminate against the vast majority of children of a different religion. And then in another court case, exemption. So in North Carolina, does anybody know about North Carolina exemptions for religious reasons?
Yeah. I think they do. They do allow it. Anybody know better that deals with it on a daily basis?
I've never had a parent who asked for that.
We do allow it. We had one this year.
Oh, we do.
that when they came to kindergarten, they waived the vaccinations due to religious beliefs, and we had to accept them.
Yeah.
Okay.
And that's a growing trend. At some point, we're going to get to the point where half the children in school are vaccinated and the rest of them are going to get everything that they get.
Right. I think you're right. I think it is growing. So residency requirements. I know this is something that comes up in our district frequently with transfers. And so there's a difference between a residence and a domicile. Public schools educate school-age children who reside in their, let me fix that, in their district with intent to stay. So the residence is defined as the actual dwelling place of the students. The domicile is where you intend to stay for an indefinite amount of time. So just because you own a house in one district doesn't necessarily mean that's your residency. There was a court case in Texas involving 3 grandmothers who had custody of children, or their children lived with them, but because they were not the legal guardian, there was some question about is that their true residence or not, and the courts ruled that if that's where the child stays every night with the intent to stay there for the amount of time, then they do in fact have residency there. There was another court case in New York where families were purchasing pieces of land that were on a district line so that they could have a choice in which district they would send their children to school in. So again, the court ruled that wherever that child is, and I've always said with our office staff, we've got to look at where does the child lay their head at night, where they typically reside. That's what we go with. So curriculum standards, this is an area where the courts have generally been hesitant to intervene in matters related to public school curricula. They don't feel like they have the expertise to rule in some of those areas. As long as there's no federal constitutional infringement, they typically stay out of it. And they usually advocate for knowledge expansion rather than knowledge restriction. So schools tend to develop secular curriculum to avoid advancement of specialized groups. So you often have special interest groups who come through and want to have their input. It's usually your ultra-conservatives, your ultra-liberals, who want to have input on the curriculum and the materials that you use in your curriculum. So some groups want to advocate for censoring textbooks and literature used in school. I know there was some cases here in Burke County several years ago of people brought up one of the AIG novels that was taught in one of our high schools. They didn't feel like it was appropriate. Other religious groups will argue controversial topics such as atheism, homosexuality, and evolution. So teaching the Bible in school is a secular purpose and not be associated with any form of worship. So the U.S. Supreme Court ruled that the Bible could be used as a literature source to study history, civilization, ethics, or comparative religion. In the Gibson versus Lee Board of Education, where a Bible history course was in question, the courts ruled that did violate the Establishment Clause. So again, I think my advice would be just to stay away from that. But if it is in your schools, then it has to have a secular purpose. Does anybody know of any, are we using the Bible for literature in our English courses? Or I'm not aware of any courses that revolve strictly around the Bible. But do you have any locally developed courses maybe that do right now?
Caldwell County used to offer it, but due to the enrollment numbers, we haven't offered it in 2 years. But it is in our curriculum guide.
Okay. That's interesting. I don't think in Burke County not since I've been in administration. I think some of our humanities classes may have used it as a source. They may have read excerpts of it for different purposes, but beyond that, we haven't. So in teaching intelligent design, a district judge ruled that teaching intelligent design theory unconstitutional due to religious connotations, and it should never be presented in a way that violates the Establishment Clause. And the case that defined that was Kitzmiller versus the Dover Area School District. And so on the flip side of that coin, you have the evolution with a couple of different court cases here. In Epperson versus Arkansas, the law said it was illegal to teach evolution. It was deemed unconstitutional. It was a case provided clear distinction between science and secular religion. And then, of course, you're all familiar with the Scopes and Monkey trial. Well, the law prohibited any theory that conflicted with Genesis. So basically, it should be taught as a theory, not a fact, and teachers should refrain from sharing their personal views, philosophies. So you're not endorsing any kind of evolution theory over any other theory regarding the origin of life. The fourth edition of the book, some of you with the fifth edition may have more updated information, but they put a large emphasis on No Child Left Behind. So I wonder if it had more updated information or not. But what we had here was this was the first kind of big wave of federal involvement in schools and dictating some of the things that are happening in schools. So No Child Left Behind increased accountability, increased flexibility and local control. It expanded options for parents, and it put an emphasis on teaching that was proven to work. So some of the implications that came out of that legislation was states had to have an accountability system. They were held accountable for their participation rates. They had you probably remember the adequate yearly progress. School choice emerged from No Child Left Behind, or it gained traction from No Child Left Behind. There was mandated school improvement, and teacher qualification was looked at very closely, along with the paraprofessionals. So did the fifth edition have anything more than that anybody would want to share? Okay. Intellectual property and fair use laws, the Copyright Act considerations. Basically, keep in mind these 4 points whenever you're thinking of duplicating work. Is the purpose or use commercial or educational? Work, how much of that material are you going to use? Are you using it in its entirety or just parts? And the impact of the use. Teachers can produce single copies of copyright materials, but not multiple copies. So I think all schools go over that every year. Use of the internet for instruction. Again, this is the fourth edition, so I imagine the fifth edition may have more updated information, but they discussed the Children's Internet Protection Act, and basically it delineated the responsibilities for different people within the school system. The school officials have a responsibility to provide procedures for the use of the internet, filtering software. They have to communicate that access to the internet is a right, not a privilege. Districts or officials should provide parental consent, clearly communicate policy to parents and students and teachers, and disciplinary action for misuse of the internet. Teacher responsibilities included selecting materials appropriate for age and maturity of students, and then parents also have responsibilities as outlined by the CIPA, the Children's Internet Protection Act. The parents should be aware of guidelines, monitor school activity, and reinforce acceptable use guidelines. So grading in academic environments, courts are, like I mentioned earlier, are usually reluctant to intervene in academic matters. The Fourth Circuit of Appeals, which we are in the Fourth Circuit, refused to intervene on a matter of third graders that were not promoted based on a reading measure, and the courts don't feel equipped to evaluate academic performance issues. So it made me think, I don't know what state this was in. It was in the Fourth Circuit, but I just wondered if it was North Carolina ready to achieve legislation. I imagine it wasn't, since this is an older edition, but
yeah, you remember when we had the gateway for third graders? It's been years ago. That
Yes.
was probably the case.
Yes. That might be it. I bet you're right. So case law around grade reduction due to absences. The court does allow grade reduction due to absences. Grade reduction. There was one case that involved a band concert where students played unauthorized music and a guitar piece, which went against policy, and they were given a letter grade of an F. So I think the courts are somewhat divided on grade reduction due to academic misconduct. There was another case with alcohol use where students received a 4% grade reduction, and the court deemed that arbitrary. Their alcohol use has nothing to do with their grades necessarily, so they did not uphold that. The courts do give their opinion on the fairness of assessment programs. One common challenge regarding testing is whether or not tests are used to track students. So they weigh in on that. Grade reduction due to absences was upheld by the courts in Michigan. Physical punishment for poor academic performance. This has not been supported by the courts. It's pretty consistently not supported by the courts. That we should not inflict physical punishment for conduct that's not related to disciplinary infractions. And withholding diplomas. I know when I was a high school principal, we got that question from teachers all the time. Well, if they do this, can we hold their diploma? If their requirements are met, they must be awarded a diploma. You can't hold their diploma if they don't pay off their lunch debt, or if they don't bring back textbooks. You can deny their participation in the ceremony, but you can't hold their diploma. Last section was on educational malpractice. They defined academic injury. This is where teachers allegedly failed or were unable to meet minimal standards of instructional competency. And the courts have really shied away from this. They have a hard time teasing out in these cases if it's truly the teacher's ability or if it's lack of ability on the student's part, motivation on the student's part. That's a really hard thing to judge. So in versus San Francisco Unified School District, when he graduated, he couldn't read above a 5th grade level, and the court could not establish standards of care for classroom instruction. They just said, there's not enough information. We can't make a ruling on that. Hoffman versus Board of Education. This student took a verbal abilities test at age 6. He was 1 point away from being what they called normal. And based on that score, he was placed in a class, an EC class, for 11 years. And later he ended up scoring a 94 on the IQ test, which is in the normal range. A lower court held that was considered negligent on the school's part. Appeals court overturned that decision, that the Board of Education had not breached its duty and should not be and this shouldn't even be entertained by the courts. So I imagine we may see more and more of that come up in court cases. I know with EC law especially, there's a lot of this kind of discussion. So in summary, the state legislature has responsibility to educate all children. Defining curriculum lies with the legislators. Courts typically don't intervene when it comes to curriculum matters. Secular curricula should be developed to avoid First Amendment conflicts. All schools are held accountable to close achievement gaps. Students can be penalized academically for absences, for truancy, but policies should be fair and consistent. Compulsory attendance policies are defensible in court. Homeschooling is permissible but not deemed a fundamental right. And reasonable tuition fees, we didn't talk about that, can be imposed on students who attend outside of their district, which we do that in Burke County. We charge a processing fee for transfers. And districts can require mandatory immunizations. So, any questions or comments?
You would be happy to know that educational malpractice did not make chapter or edition 6 of the book.
Oh, okay.
I do have a question about attendance and students. With attendance, if a student is tardy, or check out early after so many, after 5, that constitutes an absence. But like in Power School, you can't track that. So how do your schools track it? Because really there is no consequence for it, because in Power School it doesn't track the absence. And then when I talked to our school social worker, she says that if it doesn't show in Power School, that's the document they use to decide if they're going to take a parent to court or mediation about absences.
We still keep our attendance on paper. Our bookkeeper makes us, so we double check everything, and so we have it in Power School and then paper rosters.
Oh, okay. Anybody else? Thank you.
All right. Okay. How about we take a couple minute break and then we'll come back, and Kristen, I believe, is up with chapter 13. That's a short one too. All right. How about I had something up here, but I've lost it. Some entertainment. About a 3-minute break. We'll be back.
Pam. Pam. She can't hear me.
Yes.
Honey, what in the world?
I've got pneumonia. I'm working on it.
Bless your heart. Lay down.
I'm doing a breathing treatment right now.
Oh, okay. Take care.
Thanks. Night.
All right. Welcome back, everybody. Kristen, are you back?
Yes, I'm here.
All right. I think I've turned it over to you.
Okay. So I will wrap up our school law and the public schools book with chapter 13.
Which was really unfair, Kristen, because this was the shortest chapter.
But you have to remember, I had the worst chapter out of the other book.
Okay.
Okay. So we're clear on that. No. Okay, so I had obviously the public school finance, our final chapter, and the 10th Amendment says that the powers that are not delegated to the U.S. by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. That means that the states are voluntarily responsible for the support of public schools because it is not mandated federally. So the tax for public schools, we have sales tax and income tax, and those are two primary sources of funding. And then we have property tax, which is the most abundant source for state funding. The people who support property tax are supporters because of the low volatility rate, and then the opposers say that it causes a lot of disparity across districts that are affluent and then less affluent, causing there to be more money for the schools in the affluent districts and less money in those that are less affluent.
Right. Remember, we saw, I think Frida did something, was it last week, Frida, where you showed the disparity between Chapel Hill and some other districts? That's
Yes,
why.
sir.
It's property
Yes, sir.
taxes.
Yes. And so we have three types of taxes. We have the progressive, regressive, and proportional. Progressive tax is a rate that increases and decreases. The more money you make, the more money they take. And those are your personal income and your property taxes. The regressive taxes, the rate decreases when the base increases, and that's like gas and cigarette tax. And then proportional taxes are flat rates such as sales and estate tax. So tax rates are based on estimated revenue needed to meet the financial needs, and then they're distributed out. Projections for the tax rates should be made realistic and in good faith, and they should be based on defensible grounds. So you should be able to tell why you need them and defend why you need them. So a key case in tax rate case was Perron v. the City of Boston. And in this case, the state court held that local districts, school districts, had no inherent power to levy the taxes. So the districts themselves didn't have the power to do that. And to tell which kind of taxes to use or the rates to use. And so the legislature of the legislature does have the power to delegate the taxing authority to local districts if the state legislature so chooses.
Does North Carolina so choose?
Yes. Don't we get individual tax rates in different places? Or is it?
Well, North Carolina doesn't designate it to school systems.
Right. But to the local, the
locals don't designate it either. I may be wrong, though. Does Elkin City have a special city tax just for schools?
Yes.
But it is levied by the Elkin City Council, right?
Yes.
Not by the
Elkin
school.
Board of Education, because you guys can't tax. Okay.
Right.
Sorry, Kristen.
Oh, you're good. Thank you. So there's a formula for equity funding in education. Property tax is the most frequently used tax to support education, which, as we know, and as Frida showed us last week, that it can cause great disparity throughout the state based on the local revenue due to wealth. So in an effort to bring equity to the states, a formula is used, and that formula is state aid minus the local effort. The formula is used in an effort to provide an equal education opportunities for all students, regardless of their socioeconomic status. And so there are several cases in equity and adequacy funding. And I have to say that as I was reading through this, I kept waiting on the Leandro case to come up, but it never did. And I'm not quite certain why, but maybe you know, Dr. Stone, but it never came up. Do you know why?
It would in North Carolina, but I guess this is, I just guess it wasn't important enough to make the national book.
National, okay. So equity equals fairness, and which suggests that communities, both rich and poor, are taxed at similar rates and have equal access to similar amounts of revenue. But this is not, the case in real life, because if you have a rich community and then a poor community and they're taxed at similar rates, because of the percentages and math, one is going to get more than the other. And so we go to terms of adequacy, where you have to meet a minimal level of funding, and states or districts are awarded an adequacy rate, which is a minimal level of funding needed to teach. But adequate funding equals adequate education rather than an excellent education. And so we have let me go to turn my page. The DeRolf versus the state of Ohio. And in this case, it was a class action suit representing over 500 school districts who sued the state for a failure to provide an efficient education system, as the state constitution said that every child should be afforded. And then the judge in this DeRolf v. State of Ohio case ruled that the public education is a fundamental right, and that the legislature must provide an improved and more equitable means to finance the education. So it did not cause an overall funding overhaul, but in the state of Maryland, where this case was, there was a new system of finance that was brought about. And then we have the Bradford v. Maryland State Board of Education case, where they said that the current system of finance violated the student's constitutional right based on the inability of this system to provide an adequate education. And then we have Texas, the Texas cases of the Edgewood, and this has kind of, and the way that I read this, it was, I guess, similar to the Leandro case, just for the simple fact that it drug out for many years, and they kept coming up with new finding, or a different layer, I guess, to the original case. And so Edgewood Independent School v. Kirby, and this was filed by the Mexican American League Defense and Educational Fund, and in 1984. Kirby alleged discrimination against poor school districts. They said that it violated 4 principles of the Texas state constitution. In 1987, it ruled that the state system of funding was unconstitutional. And then in 1989, it unanimously confirmed the trial court's ruling, and it ordered the legislature to develop an equitable system. And they had 2 to 3 years to get this finished. So it was ruled on in 89, or they had 1 year to get it implemented. And then for the 1990-91 school year, they needed to develop an equitable system. And then 91 came, and we ended up in Edgewood 2. And then it all, once again, challenging the funding system. And then 93, the legislature looked at another bill. And then in 95, Edgewood 4, again, the Texas court held that the new system that was put in place in 93 or 92, sorry, was constitutional. So the number 4 case supported the verdict of the number of Edgewood 3. And then Edgewood 5 is from 1998, and it said, the course case said that equity was eroding by allowing property-rich districts to escape the recapture provisions of the new bill that was passed with the Edgewood 4. And the book says that the Edgewood 5 case had not been ruled on or heard by the state Supreme Court. I Googled it. I'm going to be honest, I didn't spend like hours looking for it. I could never find that it was ever, but I can't imagine that 20 years later it's still open. Do you know, or is that even pertinent information?
I would doubt it. I would imagine it's settled law now.
Yeah, and I guess
next case that comes up, it'll be something other than Edgewood.
Right. And so my thing is, it just is an example of how finances can go on and on and on forever, because we do have wealthy places and schools that have low, or communities that have low socioeconomics. And so I think there's always going to be an area that can be challenged there. And so other legal challenges that schools face are the fact that the tax systems are designed to generate school revenue. They are unfair, and they do not apply equally to all taxpayers. The challenges that people will make are that these school funding is based on the Equal Protection Clause of the 14th Amendment. Others will make challenges to the formulas that are used for funding. And then another challenge that is very common is a challenge to, are we providing an adequate education? And so there are 3 cases in involved in challenges. And so the Serrano v. Priest case challenged the funding system to be unconstitutional, which is very common whenever you're reading about financial cases. The basic view of the court in the Serrano case said that the quality of a child's education should not be based on the wealth of the district that the child resides in. So if you're in a poor district or in a wealthy district, you're both places should get the same amount and the same type and best education. The Serrano case was an instrumental case that established fiscal neutrality standard used by the court in California to address wealth disparity. And so then we have the Robinson v. Cahill case. And this case was in New Jersey. And the court said that a large number of children in the state were not getting an adequate education because of the amount of funding that or the lack of funding that they were receiving. And then again, in the Abbott v. Burke case, it challenged the disparity of spending between the richest and the poorest districts. So you can see that most finance cases are challenging similar things. So a landmark case in which are cases that are known nationally, and that would be San Antonio Independent School District v. Rodriguez. And this case kind of sparked an impact on public school finance across the nation. And it goes back to, it's California, and it referenced Edgewood and the equity on behalf of minor children. And it ruled that the Texas finance system was unconstitutional under the Equal Protection Clause of the 14th Amendment. The Supreme Court ruled this case in a 5-4 decision. and it reversed the ruling of the court. So the court indicated that the Texas funding system did not work to the disadvantage of any class group, and poor citizens throughout the system were not disadvantaged. So that's what the Texas court said, but the Supreme Court ruled against that, and they reversed, so that yes, it does. And so after this, there were 49 different states that had litigation regarding public school finance. And so the Rodriguez case, I'm looking at my notes, just one second. So the states have differences in their constitutions and the state statutes. So it's hard to have consistency among the litigation between the states because of the differences in how the states are written. So then we have the Williams v. California case, and this case talked about educational quality and the educational quality in relation to poor students. And in 2004, the state of California decided not to challenge Williams and they went into a settlement with this family. So there were some cases after the landmark Rodriguez case, and they challenged the states and asked the question, does the state provide the basic resources for a sound education? And do all children have a fundamental right to public education? And then another case that was important during this time of financial landmark cases are the CFE v. the State of New York. And this case said that school children in the state were not receiving the constitutionally mandated opportunity for a sound and basic education. So you can see that there are many cases regarding this. We also, after the Rodriguez case, another key case was the Montoy v. the State of Kansas. And in this, the court looked at, and they found and ruled that the state did fail to contribute resources equitably. And through this case, they found that there was a 300% funding disparity between the poor and the wealthy districts. And then in an Illinois case of Lewis E. v. Spagnolo, the court ruled that the plaintiffs in question had the education are solely the responsibility of the legislature and not to the relationship of school funding to the educational quality. And it was a difference between public school students, and the students require different levels of resources based on their background. And so it's kind of a different spin on the education cases. And so public school finance is bathed in court cases. And so it all stems back to the fact that the public education is not mandated by the U.S. Constitution, and therefore it is up to the states to decide how that is going to be carried out. And we have a lot of disparity among the states in how the legislation is written for public schools. Any questions?
All right. You know what? My biggest disappointment in this chapter, and not you, Kristen, is that they didn't do a Leandro study. But we'll get a chance. Trust me, before you get out of this course, we'll get a chance to do a Leandro thing. All right. I have one more thing I want to share with you all, and then we will break for the night. And that has to do with, as I've been reviewing the scenarios that you've been sharing with me, Occasionally, I'll send back a comment to you. I'll share something back with you. But it occurred to me that there's a couple of things that I wanted you to be aware of, because from your scenarios, sometimes this will help you as you're moving forward with other scenarios, or maybe help you with the court case. So let me real quickly get back to let me get to this, because this is something that I think is important. Okay, from the scenarios, and all of them basically, to me, the ones that we've had so far, most of them, if not all, do have some duty to report. And so I want to spend a minute talking to you about this, because this is a little bit of an issue that I kind of get a feel that there's not a lot of clarity about. So bear with me as we talk about the North Carolina duty to report. Now, the North Carolina law defines you as an administrator. So no matter whether you're the superintendent, no matter whether, now, well, actually, let me back up. The superintendent is a special class. Everybody under the superintendent who is not a teacher or in some teaching capacity is an administrator by definition. Whether you're assistant principal, you're the central office, human resources person, your go-to title by North Carolina law is an administrator. And so it's important that you understand the duty to report. So I looked at, and I went to the North Carolina Department of Public Instruction, and I wanted to make sure that we're really clear on when do you report and at what point do you call law enforcement, because I think that's what I'm missing sometimes in some of the case study scenarios that you're doing for me, is that you're mentioning it, but you're not putting it where I think or where I believe the law says it needs to be. So let's real briefly, let's talk about why this is there. Statute 115C-288 governs the policies and the procedures that we are all administrators. You are required to report specifically to law enforcement authorities. Now, it does say school administrators and, if necessary, law enforcement authorities. So that's where I think the distinction needs to be clarified. So the department, it was left up to the State Board of Education to develop those guidelines. They have a report, they get that, you all put these reports together, or someone in your central office compiles all the reports that you send them, and they send it to the Department of Public Instruction, who sends it to the North Carolina State Board of Education, who now are required by law to send it to the North Carolina General Assembly. That's a new step that was added a couple of years ago. All right. These are the things that have to be reported, and you not only have to give them a detailed description as well. And of course, you always want to look at your local attorney. Even in the North Carolina State Board policy, it says look for your attorney. So looking forward at this, looking and comparing these to the scenario, what I really want to get across is, when do you call law enforcement? When do you notify the superintendent? And in what other role do you have? As a rule, I would always, if I had to make that choice, I would always call law enforcement first, hang up the phone, call the superintendent's office, or whoever in your district is the designee for that call. Now, you may say, well, my superintendent's going to get really ticked if I call law enforcement. Well, not if you follow the guidelines that are before you. This is not negotiable. This is state law 115C-288. So your superintendent can get mad as much as he or she wants, but you're following the law, and not knowing the law or not knowing what role or what order the law goes in, I would suggest that you would be much safer to know the law and to follow the law. You do have to notify your superintendent, but that's the next call. Because if you do call your superintendent first and you're waiting for the superintendent to make that call, you are not following the letter of the law. Now, if your district, through your attorney, tells you, here's the way we want you to do it, I would encourage you to follow that. But in the absence of that particular guidance, I would certainly recommend you do this. Here are the things that you have to report. And you know these, but when do you call law enforcement? Assault resulting in serious personal injury. Why would you not call law enforcement on that one? Why would you wait and call them after you talk to the superintendent? if it's using a weapon. These are illegal criminal acts, which means law enforcement must be front and center, must be the ones that you call. So the reason why I want to go over this is, one, through the scenarios, I'm seeing a little bit of out of order of some of your, of when to call people. You always say law enforcement, you always say superintendent, but I want to make sure we have the order. These are criminal offenses. Criminal, criminal, police. Think of it that way, criminal. If they have an assault using a weapon, criminal. And then it defines weapons, and you can see it just goes into great detail. And there's even been some things added, like air rifles, air pistols. Those are fairly new things that have been added to it. So those are the first two. The third, assault on a school official, employee, or volunteers. Volunteers was recently added. Make sure volunteers are protected as well. So an assault on a school official, law enforcement, superintendent, bomb threats, or engaging in those, law enforcement, superintendent. So again, these are the things that you are required to report. Willful burning a school building. Okay, obviously, goes without saying, that would be a law enforcement thing. Murder, homicide, torture, anything like that, law enforcement. Kidnapping, again, huge criminal offenses that have to be reported. Now, here's where it gets a little bit of questionable about law enforcement first, or the superintendent's office, or the principal if you're a teacher and you're just observing this. I would still recommend that law enforcement comes first. Underage sale, purchase, marijuana, alcoholic beverages, those of certainly are prohibited, and that is a criminal offense for someone underage to have that. Now, if it's someone who's 19, and what is it, alcohol in North Carolina is 18 or 21? God, I haven't had that prop. 21?
Yeah.
21.
All right, so even then, these kids would still be in violation unless you've got a 22-year-old in the building, which may or may not be. Well, exceptional children, I think you can go up to 22 or 21. 22, isn't it? That's what I thought. So that would be the only case that you would have that. Controlled substance, drugs, possession of a firearm, different from possession of a weapon. A firearm could be anything that goes off that could create a damage or being even on property. Now, the law was amended in 2013 that did give law enforcement officials the right to come on campus with guns. It also gave, a little bit later on, 2014, I believe, it gave individuals the ability to carry weapons on campus as long as they're locked up and in a safe, secure place. All right. Other, rape, robbery, sexual assault. Needless to say, these are things that really, really reek of criminal intent, dangerous criminal behavior, therefore needs to be reported to law enforcement. Sexual offense, taking indecent liberties with a minor. Here's what I really want you to see. I've even highlighted it in red for you. You must report those 16, what was it, 16? Yep. Those 16 acts to law enforcement and the superintendent. When you, and it could be you, or it could be as principal or the assistant superintendent for human resources, when you have personal knowledge, that person catches you with food line and gives you personal knowledge, you have it. You've got personal knowledge. Or if you get an actual notice from a school personnel, which may be the teacher, maybe the principal, that something occurred, then you must immediately report the act to the appropriate law enforcement agency. Immediately. That doesn't leave a lot of room for second guessing whether or not I should call Steve Stone on the weekend, the superintendent. No, he may be your second call as soon as you hang up calling law enforcement.
I have a question.
Yeah.
All right. Hypothetically, let's say that teacher or community person, whatever, makes you aware of one of this 1 through 16, and not the obvious burning down school, blah, blah, blah. But let's say it deals with sexual assault, and it's hearsay. It's not, if I'm not mistaken, it's not my decision to decide whether or not it's hearsay. I report it.
Yep. Wouldn't you report child abuse? same way?
I mean, I agree. I just wanted to make sure I was.
I think if you do, you are in the letter of the law. And I think also if it turns out to be unsubstantiated, you are protected because you have followed the letter of the law.
Okay, I thought so. I just wanted to hear you say that.
That's my interpretation. But now again, those of you in Winston-Salem Forsyth who may have all sorts of guidance that the rest of us don't have because you have personal lawyers, you might want to ask. But the law's pretty clear and the consequences are pretty clear that you shall report immediately to the appropriate law enforcement agency. Immediately to me means first. Now, does that mean the assistant superintendent or the superintendent need to know? Absolutely. And at that point, you have fulfilled your requirements of the law. Even if it's just hearsay, I would highly recommend that law enforcement be involved.
Thanks for this information, Dr. Laws.
You're welcome.
Thank you.
My last name is Stone, though, Frida.
Oh my God!
Do I even look like Steve Laws?
You do a little bit.
I'm much more attractive and handsome.
But on a very serious note, thanks for clarifying.
That's all right.
A lot of things.
But in your district, because you are large and you probably have some procedures from your attorney, I would check with them too. But I think you cannot go wrong if you follow the state law. Now, the other piece I want to so that, do you see that's immediate, and that's first in the language, and then the next red line says you, the principal or the principal's designee. And remember, by definition, any of you could be the principal. You, the administrator, shall notify the superintendent in writing by electronic mail regarding any report made to law enforcement under any one of those 16 factors. So that phone call to Steve Stone on Saturday is not enough. You must also follow up in writing by electronic mail. How many of you do that? Yay! Everybody raise your hand. Good deal. And it has to be done by the end of the workday in which the incident occurred. And then, of course, the superintendent has an obligation. And when you sit in the superintendent's seat, you will see that immediately when I get information about something that has gone to law enforcement or something from one of my principals, I immediately call my Board of Education members and say, or I did, and say, hey, just heads up, this is what we know. We don't know a whole lot at this point. This is what I know. This is what you now know. And so that means that the board has been notified, and of course they can't go out and say anything about it or do any investigating because the Board of Education serves as the court at some point should it make its way through due process. So anyway, I will put this on the web. I'll put this under week 6 on the on Blackboard for you to look at. And again, I would encourage you to run it by your lawyers if you have them. But I think for the rest of us who don't have those kinds of resources, it would always be best to make sure you follow the law. And if school property, that could be any school, public building, grounds, recreation, anything. Now, if it comes to sex, it does not even have to be on school property. If you get if Miss Smith tells you in the grocery store that this teacher made a pass at his daughter and has been trying to get his daughter to meet him at a local hotel, immediately, thank you. I will thank you for sharing and immediately turn it over to law enforcement. Now, does that mean you're going to be going to law enforcement frequently? Maybe. Does that mean you're covering yourself? Does that mean you're following the consequences in the letter of the law? I believe so. Any questions on that? All right. So let me go back to one more thing, and then I'll tell you we'd be done. And I don't know, where is it? I will put North Carolina duty to report on the page. I will go back again, just speaking about, since this is our last real official Zoom session, I will go back. I have now discovered how to go to Google Docs. I will do that when before I leave here tonight, and allow you the opportunity to come in and sign up for a 10-minute session. And again, it's not mandatory, but if you want to find out where you are, what do you need, what's got to be done before the end of the semester so you can get the grade of A, give me a call or actually sign up for one of these times. Please don't leave gaps in the time. Just sign in for the next time that's available and try to do it that way. And looking forward to the calendar. This is week 6. Our face-to-face is next. We do not meet next week. It's kind of a break, so I would encourage you during the next time before we meet in a week and a half to go ahead and start getting those things into the grade center for me to grade. The time will very quickly sneak up on you before you know it. Your presentations are going under, are they under course assessments, or are they on, yep, there they are. When you finished your PowerPoint presentation, you clean it up, you're ready, go ahead and put it under presentation 1, 2, or 3. And if you're wondering what all you need to do, go under course assessments to make sure that you have completed, well, that's assessments. Go under discussion board to make sure that you have completed all the things that you need to do there. And next, the next big thing for you all to be working on, and we'll talk about this as well during next weekend, is the policy analysis. There's already there are two of them examples on the here on the Blackboard shell. Use those as a guide, because that will be a big project that we'll need to complete as well. Any questions for me?
Dr. Stone, I have a question.
Yes.
I actually got your name right.
Yes, you did. Good for you.
I may have overlooked this, but the scenarios after week 7, am I missing that, or are they posted? I may have missed it.
Well, they're posted here as a week. The week system is off, but whenever you have to do one, let's see, like tonight you had to do, they really don't follow the week thing anymore. They just simply follow, just look under the Zoom session to find those. Did that answer it, Frida?
Yes, thank you.
Okay. Yeah, it's misleading when you say week. Yeah, they're under the different days, like week 3, weeks. You wouldn't find them anywhere but here.
Okay.
But you did state last week that we complete all of those, not just the ones listed in the weekly content, the ones listed under grades, which is like through 12.
Yes, if you want to, for the extra 100 points. That'll help you get to the A in case you missed something else, which is a part of what we're going to have that conference about 2 weeks from now. That'll be part of what is it you need to get to where you are.
So other than the ethics scenarios and our 3 presentations that we've done on our Zoom nights, we have that
policy A, B, and C. Right, and we're going to talk in great detail about them next Friday, but I would encourage you to go ahead and start looking at the instructions because they're on here. I think there are 2 examples under, under week, what week is this? Under week 4, there are 2 examples of what a policy audit looks like. Those are A, B, and C put together, A, B, C, D. So if you want to go back and kind of get a feel and start, go right ahead. But here are the 2 models for you. And that's week 4. All right. So I will hopefully see some of you once I get the Google Doc fixed tonight. I will certainly see all of you, not this weekend, but the next weekend. And I hope everybody feels well. Any questions for me, or anybody want to stick around or anything? I'm available. If not, we'll Zoom out and y'all have a great rest of the week. You can go now if you like.